Thank you for joining me for this May 2nd edition of God, Law, and Liberty. And I want to begin with a couple little administrative things up front. One, I apologize for the sound. It sounds like I'm in a tin can, and in a sense I am, because this morning I could not get my microphone to work properly, and I'm having to go through a sound system that makes it sound hollow. Secondly, if in the audio playing of this video there seem to be some pauses and noise made, it's because I'm actually videoing it as well to put on my YouTube page at Senator Fowler 94, that perhaps a larger audience might be able to obtain this information. So with those things, I would like to mention one last administrative thing, and that is, for those of you who've listened to some of my recent podcasts, and you are a law student, recent graduate, college student headed to law school perhaps, or to study public policy, maybe you're a practicing lawyer who wants to restore the Constitution and a biblical view of law, reach out to me for a conference that I hope to plan this summer. You can do that at senatorfowler94@gmail.com. Now, for today's topic, I'm going to suggest that God in His providence is bringing the church back to a stillborn Reformation that was launched in the United States through the First Amendment's religion clauses. In other words, we have forgotten our purpose in Christ for our nation regarding the relationship between religion, specifically Christianity, and law. And I'm going to call us back to that today. And I think this is timely because, again, God in His providence has been bringing these law religion questions to the fore of our minds if we're paying attention. A couple of weeks ago, I looked at the arguments before the United States Supreme Court involving Maryland's story time curriculum for public school students in elementary schools. And the issue was whether or not the rights of parents under the free exercise of religion clause were being violated because they were not allowed to exempt their children out of the reading or the hearing of certain stories that conveyed a false view of human meaning and nature. Then this past week, on Wednesday, we heard oral arguments as to whether the Establishment Clause or the Free Exercise Clause of the First Amendment should apply to Oklahoma's decision not to grant a charter for a charter school to a Catholic school that would, in fact, teach Catholic precepts and provide for Mass for some of the, at least the Catholic students, right? And what was interesting, and I wrote about this at Cross Politic News, a commentary, you'll find it there, or you can find it on my Substack page, senatorfowler94.substack.com, that the precedents of the Supreme Court for the Establishment Clause and for the Free Exercise Clause actually support both sides of the dispute. And when the court's precedents seem to be irreconcilable, or you have to draw distinctions of such minutiae as to get one to apply over the other, that should be a clue that something is wrong. And then on Thursday, the president issued an executive order about religious liberty and established a Religious Liberty Commission. And I suspect it will have all kinds of religions represented on it. And here is my concern. While I appreciate the intention and the desire to minimize discrimination based on religious views, as a Christian, I cannot embrace that all religious views are equal or produce the same effects in society. And it's impossible for the government to be completely neutral. And the question is then, will those members of the commission understand what I'm going to cover today? And will the church rise up on its own accord without the horses and chariots of the Trump administration to fulfill its God-given purpose that I believe was reflected in the First Amendment's religion clauses, and specifically the free exercise clause? I'm going to provide some history today that I think will be helpful for us understanding what we need to get back to. And part of what I put in that commentary that I've mentioned, that's on Substack and Cross Politic News, is that Christian lawyers need to work to unravel the application of the First Amendment expressly directed to Congress from its application to the states under the 14th Amendment's due process clause. Now that's a big statement. Lawyers would appreciate it, laymen may not. If you want to understand how the 14th Amendment's due process clause came to apply the First Amendment directed at Congress to the states, again, send me an email. I'll send you a chapter from my book, Recovering the Constitution, that explains how we got this perverted notion that a clause directed specifically by its subject to Congress now applies to the state of Oklahoma or Tennessee or Michigan or California. But let's take an opportunity today to look at the history that brought about the First Amendment and what its true intention was, and what I believe God's purpose for further reformation was intended by it. Now, to understand the First Amendment, it has to be put not just in the context of its text, but its history. The Supreme Court has said that repeatedly, particularly in the last few years. And as I said, the text is very clear that the religion clauses apply to Congress. That is the one subject of the whole one sentence that is the First Amendment. But its historical context helps us understand what was going on. Now, as I said in a previous podcast, and I've said in previous commentaries, the word religious liberty was an alternative to convey the idea then prevalent in the beginning of the colonies coming from England to rights of religious conscience and the freedom of conscience. And in fact, you'll recall I mentioned that Jefferson and Adams and Washington talked about these concepts that we were fighting in England over religious toleration because the state and the church were so intertwined that each spoke for the other, right? Versus religious liberty or liberty of conscience. And we're going to talk about that over the next few minutes. But the liberty of conscience, I said, related to one's beliefs about God and the relationship of the conscience to the worship of God and the worship of God, not so much as to external civil conduct. Okay. And to give evidence of that, the Tennessee Constitution in 1870, which is right after the adoption of the 14th Amendment, which says nothing about religion in it, its section on religious liberty says that all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. That does not deal with civil conduct or conduct in the public square. It continues that no man can of right be compelled to attend, erect, or support any place of worship, or to maintain any minister against his consent. That no human authority can in any case whatever control or interfere with the rights of conscience, which again, in the first clause, was put in the context of worshiping Almighty God. It continues, and that no preference shall ever be given by law to any religious establishment or mode of worship. See, that fits very well with what I've previously quoted from Joseph Story's early commentaries, 1833, on the United States Constitution, where he said the purpose of the two clauses was to work in tandem to ensure that there would be no national ecclesiastical establishment or hierarchy that would receive the patronage of the federal government. That was the purpose of the clause. It had nothing to do with civil conduct and what would be lawful or unlawful, and it had nothing to do with saying that state laws that smack of religious virtues or Christian virtues was the establishment of religion. If Oklahoma, for example, wants to charter a Catholic school or a Church of God school or a Muslim school, the First Amendment has nothing to do with it. The states would be free, as Story said, that all matters of religion were left to the states. And in fact, Thomas Jefferson's letter was used for that purpose. And let me get to that here from a case in the United States Supreme Court called Reynolds versus United States. It's in 1879. It's after adoption of the 14th Amendment, okay? And the case, Reynolds, involved the law Congress had passed to prohibit polygamy in the territory of Utah. And it made polygamy a crime. Mr. Reynolds argued that the Free Exercise Clause said that he could not be prosecuted for that crime because his religion really required a multiplicity of wives. And the Supreme Court said, no. And in doing so, they quoted Thomas Jefferson's separation of church and state letter, and to say that the whole purpose of the First Amendment was that, quote, Congress was deprived of all legislative power over mere opinion, but was left free to reach actions which were in violation of social duties or subversive of good order. Now, where would this have come from? Let's go back to England and this discussion between religious toleration under the established Church of England and the freedom of conscience that became predominant after the king was beheaded and the Cromwell the protectorate allowed for not a toleration, but a religious liberty, a liberty of conscience. During this period between the beheading of King Charles, I believe it was, and the reinstitution of the monarchy in the Glorious Revolution of 1688, Thomas Goodwin and John Owen and other that had been part of the Westminster Divines came together to adopt something we hear little about called the Savoy Declaration in 1658. And while they appreciated what the Westminster Confession said, and while they appreciated the liberty of conscience being protected under the Cromwell Protectorate, they were concerned with still whether we should have a congregational form of Christian unity, much like the Southern Baptists think of, that each congregation stands on its own. For example, each Church of Christ stands on its own, or have a Presbyterian form of government where the local congregations are joined as a part of a presbytery, which are under a larger presbytery, so there's always a congregational order and polity supervising the various churches, which was still a liberty as respects a state church that licenses preachers, orders a common book of prayer be used, orders vestiges and vestments and other things. Okay? And here's what the Savoy Declaration says that expands on the Westminster Confession and specifically the issue of conscience. Quote, "The liberty which Christ has purchased for believers under the gospel consists in their freedom from the guilt of sin, the condemning wrath of God, the rigor and curse of the law, and in their being delivered from this present evil world, bondage to Satan and dominion of sin, from the evil afflictions, the fear and sting of death, the victory of the grave, and everlasting damnation, as also in their free access to God and their yielding obedience unto him, not out of slavish fear, but a childlike love and willing mind. All of which were common also to believers under the law," referring to Moses, "for the substance of them, but under the New Testament, the liberty of Christians is further enlarged in their freedom from the yoke of the ceremonial law, the whole legal administration of the covenant of grace, to which the Jewish church was subjected, and in greater boldness of access to the throne of grace, and in fuller communications of the free Spirit of God than believers under the law did ordinarily partake of." And then in Article 2 it says, "God alone is Lord of the conscience, and hath left it free from the doctrines and commandments of men, which are in anything contrary to his word, not contained in it. So that to believe such doctrines or to obey such commands out of conscience is to betray true liberty of conscience, and the requiring of an implicit faith." Now see, that would get to the concept in the Catholic Church. You don't really have to understand all this. Just take communion, come to confession, say the rosary, do your acts of penance, and that's an implicit enough faith for you to escape the fires of hell, for example, or to know all you need to know about God. And he says, and on the other hand, an absolute and binding obedience is to destroy liberty of conscience and reason also. So what they were trying to say as they were approaching this time of what's going to really happen with the freedom of religion, the liberty of conscience, and the problems with the protectorate and the clamoring of some to restore the monarchy, the Savoy Declaration is issued to say, we don't want to return to an implicit faith. Just do these things. Go to church, wear these robes, swing this incense, whatever it might be, read out this common book of prayer. That's good enough. We don't want that. But we also don't want an absolute and blind obedience to whatever the magistrate says regarding our conscience before God. Okay? Now, let me put this in the context of a scripture verse, 1 Timothy 1:9, because this is a problem that has roiled the church from the beginning. And here's what the Apostle Paul wrote to Timothy in chapter 1 of his first letter to Timothy, beginning in verse 5. "Now the end, or the telos, of the commandment," some translations use the word law, "is charity out of a pure heart and of a good conscience and of faith unfeigned." In other words, to not operate out of a pure heart towards God, out of a clean conscience before God, and on the basis of faith is the works of righteousness that are filthy rags. And then he adds this, "From this, some having swerved have turned aside unto vain jangling." And I would like to submit that in much of what we make about the free exercise clause, we have swerved into vain jangling. And he said, these are persons who desire to be teachers of the law, but they don't understand what they say or what they affirm. But the law is good if a man use it lawfully. Now, there's a critical statement. how can you use the law unlawfully? Now, let's move on, because during this debate that's taking place in England, and this has to do with America's purpose, John Owen wrote a treatise called Truth and Innocence Vindicated. I think it was written in 1689, maybe. And it was in the context of the Church of England being reestablished and religious freedom or freedom of conscience being again squelched by the Church of England. And what had been written was a book in support of the magistrates' supremacy over the matter of conscience. Okay? And here's what Owen said the book was about. And it'll help make some of the comments to follow particularly relevant. The author of the book, supporting the State Church of England, Owen characterized as saying that he would require all subjection unto the magistrate in things of his proper cognizance. That is, all things necessary to public peace and tranquility in this world, the great end of his authority. But he also asserts that there are things of God which are to be observed and practiced, even all and every one of his commands, according to the magistrate. And he says, you're confusing the role of the magistrate and the role of the church. You're confusing these two governments with jurisdiction that are supposed to work together. And he accuses this author of saying that if people have the right of private consciences, those submitting themselves freely to the sovereign power and government of magistrates and things belonging to public tranquility, but they have the liberty to express their obedience to God in the exercise of his outward worship, then we will have, as independent churches, as congregational churches, as Presbyterianly organized churches, established a rival supreme power against the magistrate to the usurpation of his crown and dignity. And Owen says, that's a logic I was never acquainted with and of which I am not going to now inquire. In other words, he says, that's just stupid. You don't recognize these spheres in which the church speaks to the individual and to the community in certain regards, and the government speaks to them in other regards. And when Jesus said, render to Caesar the things that are Caesar's, and unto God the things that are God's, he was saying the magistrate has a lawful authority, but so does God in relation to our relationship to him and our worship of him, which would recall to our minds the story in Luke where the young man comes to Jesus complaining that his brother is not sharing the inheritance with him properly. And Jesus says, aren't there magistrates to handle that? But you need to be careful about greed in your heart. See, Jesus understood and recognized there was an authority in the magistrate, and you needed to go speak to the magistrate about that authority and its proper exercise. But I'm worried about your relationship to me and the covetousness that's in your heart, because your concern reflects that you're not operating out of a pure heart and a really clean conscience and faith unfeigned. Now, so how does this work? Let's go back to Joseph. I wanted to mention this. Owen, in his book, Truth and Tolerance Vindicated, makes this important statement, and let me find it here real quickly, is that he says that there was a Reformation that was taking place, okay, and let me see here. Where is that statement? he says essentially that, oh, here it is, that it's not the fault to be cast, this conflict between freedom of conscience, religious liberty, and toleration. He says the fault is not to be cast on the first reformers, referring, of course, to Calvin and to Luther before him, who went as far as well in those days could be expected from them. Whether others have succeeded in their place and room have since discharged their duty in perfecting what was so happily begun is sub judice. It's water under the bridge. We're looking at, well, what do we do now in England? And that's the point of Owens's book. That's the point of the Savoy Declaration, okay? Now, Joseph's story speaks directly to this ongoing Reformation and contest between tolerance and liberty. I'm going to quote again what he wrote in his commentaries on the United States Constitution in 1865. And he says, of course society interferes in matter of religion. You have to, in order to keep the peace in the public, to have civil order. Some people are going to think, for example, polygamy is great, and others are going to think it's horrible. So somewhere we're going to interfere in somebody's religion. But he says this, but this is a point wholly distinct from that of the right of private judgment in matters of religion and of the freedom of public worship according to the dictates of one's conscience. And he goes on to say that any attempt in the First Amendment to level all religions and to make it a matter of state policy to hold all in utter indifference, that's exactly what the United States Supreme Court is trying to do by its notions of establishing any religious precepts and free exercise. It's trying to be neutral when the founding fathers were too smart to understand government can't be neutral on civil order. And he says, any attempt like that to level all religions would have created universal disapprobation, if not universal indignation. And then he makes this statement that has to do with what Story was seeing as the ongoing Reformation. That Owen was saying, you know, the first reformers went as far as they could in their context, and we have to leave that water under the bridge, but now we need to move forward. And here is exactly what Story says. It still remains a problem to be solved in human affairs, where the public worship of God and the support of religion constitute no part of the policy or duty of the state in any assignable shape. And by the state, he's not referring to the states, but to the state as a body, as a governing organism. Okay, so it was directed to Congress and the federal government. Then he says this: the future experience of Christendom, and chiefly of the American states, must settle this problem, as yet new in the history of the world, abundant as it had been in experiments in the theory of government. In other words, we've had these ongoing battles from the investiture struggle to the Lutheran and Germanic Revolution, to the Puritan Revolution, the English Revolution, the wars of religion, the civil wars in England, the fight over religious liberty and religious tolerance. We've had all of these fights, but he says it's as yet new in the history of the world, whether we can actually do it. Why? Because England moved back to toleration after a period of religious liberty under Cromwell. So we got to try it again, he's saying. And that's what America was in Providence charged to do. Can you have a non-national church leaving religion to the states, and still have a national kind of order in the civil realm of civil liberty. Okay? And here's how the Supreme Court resolved it in the case I mentioned earlier, in the Reynolds case, is that the court said, and let me just give you some quotes because they're good. This is the case dealing with Congress outlawing, making criminal polygamy, and it being challenged as a violation of the Mormons' religious liberty. He says, the question is raised whether religious belief can be accepted as a justification of an overt act made criminal by the law of the land. Everybody has to live with it, okay? So it's not a question of whether Congress can prescribe laws. Well, they can. It's a territory, and the Constitution gives them the right to do that. Then the Supreme Court notes the word religion is not defined in the Constitution. Well, that's obvious, isn't it? So that's why you need to take the text back into the history to see what they meant. The court continued, we must go elsewhere, therefore, to ascertain its meaning, and nowhere more appropriately, we think, than to the history of the times in the midst of which the provision was adopted. The precise point of inquiry is, what is the religious freedom which has been guaranteed? You see, that question is being completely overlooked, and we're saying, well, it means you ought to be able to do whatever you want to do in the civil liberty realm, okay? Because my religion would require me to bake a cake or not bake a cake, or to perform this adoption or not perform this adoption as a lawyer, right? To read this curriculum, not read this curriculum. And that it's in that context where the court, and I'll repeat it again, said Congress was deprived of all legislative power over mere opinion, but was left free to reach actions which were in violation of social duties or subversive of good order. So the only question which remains, again I'm quoting from the court here, is whether those who make polygamy a part of their religion are accepted from the operation of the statute. If they are, then those who do not make polygamy a part of their religious belief may be found guilty and punished, while those who do must be acquitted and go free. This would be introducing a new element into criminal law. Laws are made for the government of actions, and while they cannot interfere with mere religious beliefs and opinions, they may with practices. Suppose one believed that human sacrifices were a necessary part of religious worship. Would it be seriously contended that the civil government under which he lived could not interfere to prevent a sacrifice? Or if a wife religiously believed it was her duty to burn herself on the funeral pile of her dead husband, would it be beyond the power of civil government to prevent her carrying her belief into practice?